This is a classic case of extortion. These people who control the ED and the ED conducted raids, etc., or started investigations against certain companies. Companies paid electoral bonds to the ruling party, which was controlling the ED and those governments, sorted of money through these electoral bonds.
Who's respondent number 2?
He is the private complainant.
Yes, sir.
And I am appearing for him.
Yes, sir.
Yes, Lord. So the argument is that this can't be extortion. So let's see what is the allegation. Allegation is that these people who control the ED and the ED conducted raids, etc., or started investigations against certain companies.
Yes.
Thereafter, when those companies paid electoral bonds to the ruling party, which was controlling the ED and those governments.
Yes.
Thereafter, the harassment by the ED stopped, and in this way, they were extorted of money through these electoral bonds. Now, my learned friend said that this can't be extortion. Just see the definition. Your Lordship is aware of the definition of extortion.
Yes, sir.
Whoever intentionally puts any person in fear of any injury to that person or to any other and thereby dishonestly induces the person so put in fear to deliver to any person any property or valuable security or anything signed or sealed which may be converted into valuable security commits extortion. Now, if they put the fear in the minds of the companies that the ED will arrest them or the ED will raid them, etc., and thereafter, Milord, they are forced to buy electoral bonds to give them to the party which controls the enforcement directorate. And thereafter, the enforcement directorate stops the action against those companies. This is a classic case of extortion. What else is extortion? Therefore, how can anybody say that this is not extortion? And what has been done? Only an FIR has been directed to be registered. In fact, even the Supreme Court, when it gave the judgment in the electoral bonds case, had said elaborately that they fear that these bonds may be used for bribery, for quid pro quo, etc. And this is what appears to have happened. It is not merely quid pro quo, it is actually extortion by putting the fear of arrest, putting the fear of raids, etc. in the minds of those people running those companies and thereby inducing them to buy electoral bonds. And after electoral bonds are bought and given to the ruling party, thereafter everything is stopped. This is absolutely the classic case of extortion. And only an FIR has been ordered to be registered. Investigation will follow now. When we went to the Supreme Court asking for a court-monitored SIT into these offences, court said, yes, offences may have been committed, but for that, there is no need for an SIT. Let the law follow its normal course. That means let the normal criminal procedure be applied. And that's what exactly has been done by the complainant. He made this complaint to the magistrate that this investigation needs to be done. He first filed the complaint. Thereafter, when nothing was done, he went to the magistrate. The magistrate has only ordered an FIR and an investigation. And these are the people who are, among others, who will need to be investigated in this extortion. So therefore, my Lord, it's a perfectly valid case. And at this stage, my Lord, at this stage, no plea can be raised that sanction has to be taken at this stage, because sanction will be taken at the stage of taking cognizance.
That is not the plea also.
Yes, that's not the plea.
That is not the plea presently.
Yes. Today the plea is only that this is not a case of extortion. And I am saying that this is the most classic case of extortion. If ever there is a case of extortion, this is it. When you put the fear of arrest and put the fear of raids, etc. in the minds of a company and thereby induce them with that fear to give electoral bonds to the party which controls the ED, and thereafter the ED stops the action. What else is extortion? This is classic extortion. And I submit, Milord, that there is, if your lordship wants to issue notice and hear this case, that is all right. We don't mind that. But there is no case whatsoever of any interim order to stop any investigation at this stage. No coercive action is being taken against these people. Right now, only an order for investigation has been made that an investigation should take place. Why should the investigation not go on in such a classic case of extortion? This is my respectful submission, Lord.
Yes, state.
You are ready to commence investigation. It was referred to. You are ready to commence investigation.
Yet to commence.
Yes, yesterday it was referred. So therefore, you will not be able to say anything prior to the investigation. You will answer.
Yes, will answer. The petitioner is before this court calling in question registration of a crime in crime number 224 of 2024 after it having registration so and so, for it having been registered on a reference being made by the learned magistrate in PCR 4880 of 2024 under section 156(3) of the CRPC. The second respondent claims to be the co-president of Janadhikara Sangarsha Parishat JSP and is the de facto complainant in the case at hand. It is the case of the complainant that the case of the complainant before the concerned court that the accused in the case at hand, accused number 4, along with other accused, have indulged in extortion. Extortion to mean an offense under section 384 of the IPC and the allegation stretches to section 120B read with 34 of the IPC.
383, my lord. Extortion is
No,
384.
I'll answer.
I'm sorry.
That is
I'm sorry.
384 is punishment for extortion. Yes. So and so. The learned senior counsel KG Raghavan, taking this court through the documents appended to the petition, would prima facie demonstrate that there is no case of extortion made out in the complaint or in the reference made by the learned magistrate seeking to investigate into the matter. The learned senior counsel would submit that the complaint itself is so vague that the complaint itself is vague and does not make out any ingredient of extortion, qua the complainant. Per contra, the learned senior counsel, Prashant Bhushan, right?
Yes.
Prashant Bhushan, representing the second respondent complainant, would vehemently refute the submission to contend that this is a classic case of extortion where the accused number 2, who's accused number 2?
ED.
Accused number 2, the enforcement directorate, have put fear in certain companies to execute electoral or to take electoral bonds as a quid pro quo, and the apex court, while dealing with the issue, has left it open to the aggrieved to take recourse to remedies available under the law governing both criminal procedures, i.e. ordinary law governing criminal procedure,